and get started with today's presentation. I am MHA's Membership Director, Sandy Garbrecht, and I will be the webinar's host and moderator. And with full disclosure, I am a newbie to this, so please pardon any mistakes that I may make along the way today. Before I introduce today's panel of legal experts and turn the stage over to them, I will cover just a bit of technical information for you. First, we have a few tips for you so that you can get the best experience. First, you need a good signal. You want to ensure that your webinar streams smoothly. An Ethernet connection is always best, but Wi-Fi is fine. Make sure nothing else is draining the bandwidth of your Wi-Fi while you are watching the webinar, such as downloading or uploading or streaming video. We suggest that you close all programs except the webinar so that you don't have any programs open except for the webinar software. Other programs may interfere with this, and so we recommend that you just keep things to a minimum. We also suggest that you log out and log back in if you're having problems, because 99% of problems with viewing or listening to a webinar are resolved by doing this. You can shut down the webinar, log back in, and use your registration link. This should only take a minute or two. You should be in listen-only mode right now, and you are going to remain muted throughout the presentation. You are going to have the opportunity to submit some questions. So if you see where the question box is, you will be able to submit your questions throughout the presentation, and then we will cover those questions at the end. And we would like to remind you to please keep your questions more general and not specific to your particular association. For more specific questions, feel free to follow up with any of the panelists following this webinar, or you may consult with your own legal counsel. If you can't hear the sound, we suggest that you check your audio settings. You can select computer audio. You might have multiple speakers and you may need to make sure that you're on the right speakers, or you can select phone call and dial in. And sometimes you will have static or clicking sounds if you have a handheld device too close. So we just suggest that you move items such as that away from your speakers. And if you have any poor or choppy audio quality, again, that could be due to a variety of different factors. And you may have to switch over to a telephone mode if you cannot avoid these things. And now a little bit about each of our presenters. First, we have Matt Greenstein, who is with Greenstein Sellers. Matt lives and breathes homeowner association law. He has been representing common interest communities for his entire career and provides full service legal counsel, including legal opinions for directors, interpretation of government documents, drafting and amending governing documents, and collection and lien foreclosure. Next up, we have Phaedra Howard, who is with Hellmuth and Johnson. As a partner of the firm and a member of the Real Estate and Development Practice Group, Phaedra brings her creative and strategic acumen to individuals and a broad range of entities, including condominium, townhouse, cooperative, and other community associations. She provides advice on a wide variety of issues affecting associations. And finally, our third panelist today is Carly Kauf with Smith Jaden Johnson. Carly has a wide range of legal experience and has successfully advocated on behalf of her clients at all stages of the legal process. In particular, she has experience advocating on behalf of homeowner associations in matters including everything from day-to-day questions and all the way through litigation and court appearances. And now I am going to turn my screen over to Matt, who will be our first presenter.
Okay, well, thank you everyone, and thanks for having me. The first topic that we're going to be discussing is considerations for associations due to COVID-19 and the recent executive orders passed by Governor Walz. When these executive orders first came down, there was a lot of confusion. There was a lot of questions. associations weren't sure, does this apply to them? What do they need to do to comply? And at the end of the day, there's a lot of questions about what can an association do and what can an association not do with respect to rules and policies for enforcement of issues related to COVID-19. So we're going to generally talk about the authority of the board of directors. We're going to talk about some best practices for adopting rules and policies, and then options for enforcement. And there were some questions submitted prior to the seminar that I'm going to try to also address throughout the presentation or at the end if I don't get a chance. So first off, it's important to know that the executive order applies to everybody, and it applies to the association. Now, the most recent reiteration of the executive order does expire June 12th, but the order does limit gatherings of 10 or more people in social settings. And that is a law that applies to the state of Minnesota. It applies to associations. And because the association takes action from its board of directors, it's up to the board of directors to ensure compliance with these executive orders and to address some of the basis for the executive orders, which is the COVID-19 pandemic. And so taking that into account, taking into account the CDC guidelines by the Minnesota Department of Health, it falls on the board to decide how are we going to protect our association, what are we going to implement into our association in order to protect the health, safety, and welfare of our residents, and how are we going to make sure that we're complying with these executive orders and these guidelines being adopted by the state and federal government. So I mentioned the board acts on behalf of the association. The board of directors has very broad powers under the Minnesota Common Interest Ownership Act. And when I'm talking about the act, I'm referring to the board's powers in section 515B.3-102. And the big question has come up, well, can a board take action to address these things? And there's clear authority in the statute that says, yes, the board does have authority. Under subdivision A1, the association has authority to regulate the use of common elements and regulate the use of units and conduct of unit occupants which may jeopardize the health, safety, or welfare of other occupants. And that says it right there. There's direct authority to protect the health, safety, and welfare of the occupants in the association and to regulate the use of the common elements. Looking at that, then the board has to look at, well, what considerations are we going to take into account? And I'm going to be speaking generally. Each community is different. Each community is unique. Depending on the types of amenities, the types of common areas, the size of the association, the demographic of the association, and the average age of residents, different associations might implement different policies, different rules. They might take different precautions. And that's fine. There's no bright line rule. At the end of the day, the standard of care and the duty of the board of directors is to act in good faith in a manner in which they reasonably believe is in the best interest of the association. So if the board of directors is getting together and meeting and they're addressing these concerns, they're talking about how are we going to protect the health, safety, and welfare of the occupants? How do we incorporate policies in the executive order or recommendations and guidelines regarding the COVID-19 pandemic? And they're taking those into account and they're weighing pros and cons and they're adopting rules and policies based on that, then the board has done their due diligence and they're doing what they need to do to comply with their standard, with their duty and their standard of care. So one of the things I also want to point out is that because of these executive orders and because of the clear authority to regulate based on the health, safety, and welfare, the board really does have a duty to address these things. One of the questions that came up prior to the seminar was, can an association be liable if somebody gets sick or if they're not doing something? And the answer to that is probably not, but what's going to make sure that the association is not liable is that they're going through this process, they're doing their due diligence, and the board is taking actions based on what they think is in the best interest of the association. The reason I say probably not, they're going to be liable anyway, is because this is one of those things where it'd be hard to prove the source and any kind of negligence or whether they knew or should have known. But I think put that aside, the board should be taking action. The board should be addressing the situation proactively, and then there's nothing to worry about. So under the statute, after the board has adopted rules, there's authority to enforce those rules. After notice and opportunity for a hearing, the board could levy fines. The board could impose other policies such as restricting use of amenities. And there's pretty good authority for enforcement. I'm going to talk about some pros and cons for different strategies in a minute, but getting into some of the details of what those rules and policies should be. First, the association can regulate the areas. So when we're talking about the areas, think all common areas or anywhere where multiple residents can congregate, front entryway lobbies, if there's an exercise room, pool rooms, community rooms, hobby rooms, gathering rooms of any kind, anywhere where multiple residents can congregate in one area. The association should first and foremost be regulating these areas. And the way they can regulate that is by limiting the amount of people, by regulating hours, putting other additional restrictions on use of the area, such as obligations to clean or disinfect or sanitize, or restricting use of the area in its entirety. And there's been a lot of pushback with associations and homeowners that have had that come up. Well, can we just restrict use of the exercise area? Can we prohibit it from being used? The answer is yes. And the reason why a board might want to take that type of approach is if the exercise room is small, if the equipment is close together, if there's no way to properly socially distance one another, if there's multiple people using it, or if there's not resources or an ability to make sure it's disinfected on a regular basis, the best approach might be to restrict access altogether. The association has that authority. Now, whether or not that's the best policy for your association depends on some of those factors we talked about. But you want to take into account some of these things like, is there room to properly socially distance from one another? Will there be more than 10 people using the area at once, which would be a violation of the current executive order? And what other mitigating factors can be incorporated to protect people's safety and health if they're going to be using that area? So just on its face, when we're talking about general areas where people are walking through lobby areas and common areas, there's nothing wrong with a general policy to not congregate in the common areas, not congregate in the lobby areas, to limit access to those areas and to only use them for ingress and egress or as is necessary. When we're talking about amenities and pool areas, you're going to have to dig a little bit deeper. You're going to have to decide what are the pros and cons. When we're talking about a pool area, for instance, it might depend whether or not it's an indoor or an outdoor pool. With an indoor pool, I think the social distancing issues are much more important because what we know about COVID-19 is that it's spread by breathing and the molecules in the air. And so if you're indoors, those are going to be lingering. You might want to have a more stringent policy, restrict use or limit occupancy to a certain number of people for an indoor pool. Whereas an outdoor pool, you might be comfortable allowing more people if there's a way to properly socially distance themselves. And look at factors like that when you're making their decisions. And again, there's no bright line rule. There's no perfect solution. The other major thing the board's going to want to look at is how to regulate people. And this is one that, again, gets a lot of pushback. And one of the first things that is on everybody's mind is, can we regulate and require people to wear masks? And the answer is yes. You can require homeowners or guests or residents or whoever's in the building to wear a mask when they're in those common areas. It's enforceable just like any other rule. The board would adopt this policy and then they can enforce it. Other things that have gotten a lot of pushback are regulating visitors and guests to an association. Now, this is one where there is authority and the association could say, we're regulating and we're restricting guests. We're restricting everybody except immediate family, or we're restricting everybody if there's that level of concern. Now, there's authority for that, but I think you have to look at pros and cons. You have to look at whether or not people are going to be needing assistance. If it's an elderly population, people might be relying on assistance with getting groceries, with getting prescriptions, with other care. And so we don't want to put people in a situation where we're impacting their ability to have a healthy lifestyle in their unit, but we can take action to protect the safety and health of the other residents. If the guidelines say that we recommend wearing masks when indoors, the association can follow those guidelines and implement those types of policies also. You can also have similar policies with respect to vendors and third parties who are coming on site. You can implement certain requirements and procedures to make sure that the property is staying safeguarded to the extent you can. The third thing that associations are going to want to look at is what can the association do as an entity to protect its residents in the property. And that might be as simple as hiring extra staff, hiring a vendor that does deep cleaning, making sure that the handles and the elevator buttons and things like that are being disinfected on a regular basis, that there's cleaning methods being implemented, and just some of those other basic things that will help protect the health of the residents. And those are kind of the easiest things to immediately implement. And that's something that there's not going to be pushback from homeowners on. Homeowners may or may not even know that that's occurring, but that's something that the board is going to want to look at minimum, to take steps to protect the building and make sure the property's clean, and doing what they can to prevent the transmission of COVID-19. With all of these things, the key to enforcement is adopting a clear policy. And what I've been recommending is, rather than incorporate these types of policies into the association's traditional rules and regulations, to adopt a separate policy, a separate set of rules specific to COVID-19. And this is a little bit easier because you're not going to have to provide notice of a whole new set of rules. You can send notice of the COVID-19 rules or the COVID-19 policies to all the homeowners. They're enforceable soon thereafter, as long as homeowners and residents have had notice that these have gone into effect. You can post notices about the rules throughout the building or in common areas, and then you can start enforcing them. The enforcement here is a delicate issue. And although the association does have the right to levy fines, a lot of boards I've been meeting with have chosen, rather than levying fines, which seems a little harsh and perhaps draconian for things regarding forcing people to wear masks and things. And, there's a lot of pushback in some cases from homeowners about this. They've been implementing these rules. They've been providing notice to everybody. They're not actively enforcing them with fines, but they are actively providing warnings and notices and communications to homeowners regarding the rules to encourage compliance. Now, if you did want to levy fines for violations, the association has that right. And like with any other rules, you're going to want to give notice and opportunity for a hearing prior to levying the fine. That's a requirement under the statute. And then you could go ahead and proceed to levy fines. The one guidance I would have is make sure the fine is reasonable based on the violation, and make sure that fines are being levied even-handedly against all homeowners. Certain homeowners cannot be levied fines in increasing amounts, and everybody should be fined equally for the same violations. With this, a lot of what I'm hearing back from homeowners is, I pay assessments for the amenities. You can't prevent me from using the amenities. I pay assessments for my building. You can't prevent me from having whoever I want to come over and use the common areas or use the pools or this and that. And I think when the board has gone through this process of understanding their duties and obligations, seeing the language in the Minnesota Common Interest Ownership Act, sitting down and adopting clear rules and regulations, and providing that authority for the ability to have these rules in place, that's how you're going to want to respond to homeowners who question this authority. The authority is there, it's in the statute, there's language in declarations. And the best way to go about it, instead of getting into a back and forth with a homeowner, which easily can kind of go sideways into politics and other personal beliefs or personal differences, all you want to do is stick to the legal authority that the board has, the authority of the executive orders, how it's binding on homeowner associations, and the authority of the board to take action on behalf of the association, especially when it relates to the common areas and to the health and safety of its residents. There's a couple questions that I want to run through before my time's up. Some of these I may have briefly already touched on. The general question that we've gotten from a couple homeowners, one homeowner asked, or maybe it's a board member, property manager, asked, we have a holiday celebration for residents and their guests. We have picnics at the lakefront. There's also a church group in the auditorium that includes guests. Is this a good idea? Well, I'd say probably not. Number one, if there's more than 10 people, you're violating the executive order, which is in effect at least until June 12th. The guidelines are all recommending socially distancing and not having large gatherings in small enclosures. And even though you want to promote that kind of community relationship, you want to have people be able to enjoy each other and enjoy the outdoor weather, and it sounds like the association's on a lake and there's picnic benches, I think you want to still have some kind of policies in place to protect residents. And you have to think about the fact that there might be older or more at-risk residents in the association. And if other owners are bringing lots of guests or lots of younger people who aren't socially distancing, there's that potential for transmission. And so I'd say it's probably not a good idea. If you're going to move forward with it, I think you have to weigh pros and cons, and you have to put some policies in place to encourage socially distancing and to make sure that there's not going to be a high risk of transmission of COVID-19 if there's somebody who's impacted, who's present. The other question is kind of recommendations for amenities, continue to keep them closed. I think probably until June 12th, that's probably the best approach. After June 12th, I think we want to look at what types of guidelines are in place. I think you still want to look at restrictions on the amount of people who can be in one area, maybe restrictions on use of hours, removing some equipment if it's an exercise room so people aren't directly next to each other, and having some general limitations just to still maintain some social distance practices and protect residents, as it seems like the COVID-19 is going to be around throughout the summer. Just because the executive order has lapsed doesn't mean the duty to protect the residents has also lapsed. That duty is going to remain. So I think it's better to err on the side of caution and be a little more cautious rather than open everything right back up right away. We got quite a bit of questions regarding evictions, and I'm guessing there may be some people in attendance on the webinar who are part of the multi-housing community, or maybe they manage both homeowner associations and multi-housing properties. And so generally the questions were, what's happening with the eviction moratorium? What's going to happen when this expires on June 12th? So I guess the short answer with respect to evictions is nothing has changed since the initial eviction moratorium went into effect back in March. Landlords cannot file for evictions until the executive order expires on June 12th. Prior to that, there are two exceptions where a landlord can file an eviction, and that's if there's something the tenant has done to jeopardize the safety of other residents, or if there's criminal behavior or a violation of Section 504B 171, which basically prohibits guns, drugs, prostitution, and criminal activity. I would say, though, that even with those two exceptions, what's been happening in the courts is landlords have not been successful. It's very difficult to prove a danger to other residents. That's probably a contested case. There'll be fact witnesses, and it's also limited to residences or other residents, excuse me. So I know there's been some broadcasts that have gone out from the Multi-Housing Association that have stated property managers that have been assaulted by residents were unsuccessful in evicting them because of the moratorium. The executive order only applies to danger to other residents and does not apply to danger to other people, such as property managers. And again, with 504B 171, it's a lot of fact issues. what is criminal behavior. It doesn't matter if there's a conviction or not. And those can be difficult to be successful on anyway. So you can bring those cases now if you wanted. With the executive order expiring June 12th, it may make more sense to wait. The other important thing to also note is that while the executive order is in place, you cannot terminate a lease, you cannot terminate for non-renewal, you cannot terminate possession in any manner. And so there's been a whole task force with the Attorney General's office who have been investigating these claims. There's actually misdemeanor penalties against landlords and fines if they have been terminating leases. So you want to make sure you're not running afoul of that part of the order either. And then with the CARES Act, if your property is financed by federal financing by Fannie or Freddie, there's a separate moratorium on evictions for those properties, which I believe goes into effect, or I think lasts until July 25th. But it also imposes a 30-day notice requirement prior to eviction. So it's actually going to prevent evictions from those properties until August 25th. So if the property you manage is purchased or was financed by a federally backed loan, there's some exceptions if there's like less than 5 units, but generally speaking, you're not going to be able to process evictions until late August. Lastly, there was one question about the impact on writs of recovery for evictions that were issued prior to the moratorium going into effect. So the initial eviction moratorium does not address what happens with already issued writs of recovery. There was a subsequent executive order that states that anything that's time sensitive under statute, so anything that expires, has a statute of limitations, has a tolling period, is automatically extended during the time that the executive order is in place. And so although it doesn't specifically reference writs of recovery, I think that the general thinking is that writs already issued will stay into effect an extra however many days that the executive order stays in place, however many days that moratorium is in effect where you can't actually execute on those writs. So I don't think that you will have to go through the eviction process again. You may need to file something with the court to have a writ reissued, but hopefully the courts are going to be good about that and not charge an extra fee for reissuing the writ and allow those writs that were already issued to be extended during the time the executive order was in place. So those are, I think, the primary questions on my subject. I don't want to address some of these other questions because Carly and Phaedra will be addressing those in more detail in their presentations. But after they are done, we'll have some more question and answer. And so if you have any additional questions, please use the chat function, and then Sandy will moderate those and we'll have those questions answered at the end of the presentation. So thank you very much.
All right, I think I'm up. Like I said, my name is Carly, and I'm an attorney over at Smith, Jayden Johnson, and I'm going to discuss how to deal with meetings during COVID-19, including what rights the board and the associations have to hold their meetings electronically, and how boards should handle this issue moving forward, both during the pandemic and after. So first, I want to point out that there's an important distinction between meetings of the members, the owners at the association, and meetings of the board. So the first thing I'm going to discuss is meetings of the owners. So that's going to be, say, your annual meetings, special meetings to discuss a special assessment or things like that. The meetings of the owners, the Minnesota Nonprofit Act prohibits nonprofit corporations, which includes associations, from holding member meetings by remote communication unless its articles of incorporation or bylaws specifically permit it. And so the issue, of course, is that so many of the association's documents were drafted at a time where we simply didn't consider having electronic meetings. And so many of the documents that we see simply just didn't contemplate putting that in there in order to specifically call it out. So under that Minnesota Nonprofit Act, unless those bylaws or your articles specifically say you can conduct your meetings electronically or by remote communication, and I kind of use those two terms interchangeably. Remote communication, all I mean is we're all in different places, but we're having a meeting in real time. Unless your documents specifically say you can do that, you cannot with the owners. So what that means, of course, is that associations are trying to grapple with how to deal with the requirement that they have an annual meeting. You know, almost all documents require that the association conduct an annual meeting each year. And so a lot of our clients are coming and saying, well, what do we do if the governor doesn't allow us to meet, but our documents require that we do so? And I would say you kind of have two options there. The first option is that you just postpone the meeting. You postpone the meeting, you postpone all related votes that would take place at the meeting, such as electing new board members, approving prior minutes, and other business that you would have done. You postpone that for a time in the future. Like Matt said, the current order is set to expire on June 12th. I anticipate some other order going into effect at that time, but of course we don't know what that will be. But we hope that at some point in the future in this year, in 2020, there will be a time where perhaps you can meet as a group. And so we have a lot of clients who are simply holding off until the fall. Some documents require a specific date. Let's say, you know, your bylaws require that your annual meeting be on June 15th. Well, the governor's requirements trump that document. And so the board won't suffer ramifications for failing to hold an annual meeting on that date because they weren't legally allowed to do so. Now, it gets a little more interesting when, for example, it's not an order, it's a suggestion. So for example, if through the summer the CDC continues to recommend that groups not congregate in more than 10 or other things like that, the board, like Matt discussed, has the authority to regulate the health, safety, and welfare of its members. And in doing so, can protect their members by following those guidelines. And so, in my opinion, there's not a court in the world that's going to fault a board for acting in good faith to protect its members, and in doing so, failing to follow the exact, let's say, June 15th requirement that their documents require. So that's the first choice, is to postpone the meeting. You postpone the meeting, you postpone the votes, you just wait until later and you find out what to do. If that's the choice your board wants to make, of course, you should notify your members and let them know that you're postponing it so that they know what to expect, just in terms of transparency and making sure everybody understands what the board is doing and why. The next choice is to conduct the business of the annual meeting using mail-in ballots. Unless the association's bylaws explicitly prohibit it, both MCIWA and the Minnesota Nonprofit Act permit the association to use mail ballots in lieu of a in-person meeting. So the board can choose to send all of its annual meeting information to the owners and include in there a mail ballot for any voting issues, such as, again, the election of board members, the approval of minutes, any other business that you have on your agenda to conduct at that annual meeting. In doing so, those ballots have to conform to the requirements contained in that Nonprofit Act. And the Minnesota section for that is Minnesota Statute Section 317A. And so in that statute, it lists some, requirements that the notice and the ballot have to conform to, which includes, it has to say what you're voting about. It has to allow the person to vote yes or no on the vote. You have to get enough ballots returned to constitute quorum. So for example, if in your bylaws it says in order to have quorum at an annual meeting, you have to have 10% of the members. Well, in order for a write-in ballot vote to be valid, then you would have to have at least 10% of the members respond. And that mailed notice to those owners has to state the number of responses required to meet quorum. So, you know, if you have, let's say 10 units for ease, and your quorum is 30%, you have to tell the people that we have to get at least 3 votes back in order for this to count, for this vote to be valid. You have to explain the percentage of approvals needed to approve the action. So again, you say to the owners, in order for us to pass this special assessment that we're voting on, we need to have at least 67% of the owners approve it, or whatever it is that your particular documents require. And then it has to include the deadline for returning the ballot in order for it to be counted. And so you want to say, please return your ballots to this place or this email address or this mail address by Friday at 5. Only ballots received by Friday at 5 will be counted. A side note, proxies can't be used in this scenario only because proxies are used to allow someone else to cast another person's vote, and mail ballots eliminate the need for proxies. Everyone has the ability and right to submit their own vote, so proxies wouldn't be needed. So in that scenario, that using that mail-in ballot would take the place of the business that you would conduct at that annual meeting. So, for example, if you have board members wishing to leave the board, or you have vacancies, or you have business that needs to be conducted right now, using mail-in ballots is a really good way to do that, because you know, it allows the members to feel like they're participating and to see, you know, all of that annual report information, the budgets, and the things that you would get at an annual meeting. You send that out, and then that ballot would list, for example, you know, the 6 candidates that you have for the board, and would let them choose, you know, who to vote for. I think it's also really important if you're doing a ballot by mail, particularly for board members, to include a write-in section, because you don't want anyone to feel as though they weren't able to vote for the person that they wished because they weren't included on the list. And so a really easy way to solve that problem is to simply put in a write-in candidate area. And so then when the board gets back those ballots, it can tabulate them and tell people who won and who did these, you know, what passed and all these things. Oftentimes, we've had some associations that, in addition to doing that mail-in ballot, will have sort of a town hall meeting of some sort, you know, either by phone or by video, not in person, that isn't, you know, doesn't constitute an annual meeting because your bylaws and articles don't allow for remote meetings of members, but does give people the feeling of community and participation. And, you know, sometimes they'll have open forums or allow people to discuss things, ask questions, those type of things. And so that scenario kind of gives you a lot of the same feel as an annual meeting would, while still complying with the law and the requirements of your documents. And so, like I said, far more of the associations that we see do not have the right to conduct their member meetings remotely, simply because no one thought of it. But for those that do, for those that specifically permit remote meetings of its members, again, you can run that meeting very similarly how you would run a meeting in person, but you would do so using an online platform such as Zoom or GoToMeeting or Election Buddy. There's many platforms for use, Skype. You could also use telephone conferencing. A lot of the platforms allow for a hybrid. So some people can use the video conferencing if they're comfortable with it, but other people could use the phones if they're more comfortable with it. I think that that can be very helpful for communities with older populations. Sometimes people feel that, it's overwhelming for them to do that. So it's nice to have the phone availability too. So it looks like we're running a little short on time, so I am gonna speed up a little bit. But if your association's documents do allow for those remote meetings with members, you can do that, and I think it can be very beneficial in order to get that community together and also remain safe. Again, for those, for voting, you could either do that written, like we talked about before, or some platforms do allow for live voting. So you can use that if you so choose. Again, only if your documents specifically allow it. For associations whose documents do not currently allow for remote member meetings, we suggest amending your bylaws to allow for it. And that's because it's a really pretty simple and straightforward process, and it future-proofs your associations against future situations like COVID-19 that no one could have ever thought of or contemplated, and protects you in the future. And it promotes homeowner attendance by making it easier for people to attend. Like, think of snowbirds and other people who can't participate meaningfully. This would allow them to do so. I think one of the most important things is that it allows the boards to decide for themselves what's best given the circumstances, because it doesn't require that you use remote meetings, but it would allow you to do so. And so it's a fairly straightforward bylaw amendment, and so you should talk to your legal counsel about whether that makes sense for your association to amend its documents to allow electronic meetings moving forward. I'm just going to speak quickly about board meetings, in that the Minnesota Nonprofit Act does allow for board meetings as opposed to member meetings, but board meetings can be held remotely. And so that means that you can hold any kind of meeting you would hold in person with your board of directors. You can do that via remote communication, so long as people can participate in real time. That includes telephone conference calls, that includes online meetings, but it does not include email communications. We'll talk about email communication in just 1 second. Board meetings held via remote communication still have to comply with those notice and quorum requirements. And so you can only conduct business at that board meeting if you meet that quorum requirement. But assuming you have proper quorum at your board meeting, you can conduct business by majority vote just the same as you would as in person. It would be the exact same. Now, the nonprofit, like I said, we talk about emails. The Nonprofit Act also permits boards to act without a meeting, and that can be by written action, and that's via email or in writing in a letter or whatever, but those votes have to be unanimous. And so it gives you the ability to act in an emergency situation that prevents you from having a formal meeting. But again, the board has to all agree. It has to be a unanimous decision. So if you can't get a unanimous decision, then you got to bump over and have an electronic meeting or a meeting by phone in order to do that majority vote. I am going to go and pass this off to Phaedra because I think we're running a little short on time. And so we'll answer as many questions at the end as we can. Thank you so much.
All right, thank you. Sorry about that. Somebody else muted me and I wasn't able to unmute myself. So, okay, really quickly, I'm just going to kind of breeze through how COVID-19 affects maybe your assessments and collections, rule enforcement, not the stuff that Matt was talking about, but just your general rules and that sort of thing. And then quickly talk about what do you do if you have somebody in your community that has COVID and how you can deal with that. I'm probably going to run right up to the end because we're kind of going over. So I'll try to talk as quickly as I can, but we will all stay on to do questions at the end. Anybody who needs to drop off, you know, if you have a hard stop at 2:30, that's fine, drop off. Otherwise, we'll stay on and answer as many questions as we can. So quickly about the annual budget and assessments. Some people have asked, especially back in the beginning when this was all happening, you know, should the board reduce assessments given the business closures and layoffs and all of that, especially if your association is governed under MHA, the Minnesota Common Interest Ownership Act. That requires that the assessments shall be levied at least annually, based on the budget that's approved at least annually by the association. And if an assessment has been levied, all unit owners shall pay the assessments allocated to their unit. So there really isn't any leeway there for the board to say, oh, we're not going to collect assessments for 3 months because, you know, everybody's, you know, world has turned upside down. That's not an option. Levying and collecting assessments is not optional. You need to still do it. Again, MHA and or your governing documents are going to talk about how the assessments are supposed to be determined based on your annual budget, either equally or by a percentage, depending on how you're set up. You need to keep doing that. You know, it's unlikely that that the association's overall expenses are going down. Maybe you have a large budget that you plan for this year that you're going to postpone, but otherwise, generally speaking, your expenses are staying the same. And so your budget is based on those expenses. That's not changing. You still need that money to operate. You can't waive or reduce assessments for some owners without doing it for everyone. And if you do that, then you don't have the money to comply with your own obligations to pay your vendors to do what you need to do. Pay for insurance and all the extra cleaning that Matt talked about and all of that. You need that money. It needs to be come in. So it would be absolutely inappropriate for the association to reduce assessments if you need that money for operating. You know, when you figure out your budget for next year, you can factor in, okay, what happened this year? What, you know, did we not do some of these projects that we can push off? Do we, you know, want to adjust it for next year? But for the current year, the assessment's been levied. It should stay where it is, and you should continue to collect those assessments. You know, Matt kind of talked about the argument that some people are making about, you know, if you've got all the common area amenities, the pool and the exercise room and all of those things are closed, you know, why should I have to pay my full assessments? Well, in addition to his point that the board has the authority to close those things, the bigger issue is that those assessments are not, it's not a membership fee. I'm not paying a membership fee to use the pool, to use the exercise room. What I'm paying for is to maintain the property as well as insurance and all the other expenses. So you're paying to maintain it, not to use it. And so, I mean, it wouldn't be any different if, you know, if my association has a pool and I don't know how to swim, so I never use it. I would never use it no matter if it was open or closed. I still have to pay my share of the assessments. That doesn't change, that doesn't go away. That expense is still there because the association still has to maintain the pool and all the other equipment. And again, you might have added expenses if you're trying to do the extra cleaning and sanitizing of the common areas, even if most of your amenities are closed and you're not, you know, doing extra cleaning in there because they're closed, but, you know, your lobbies and your, you know, mail rooms and whatever else that you're trying to, the high traffic areas that you're trying to clean and sanitize, you may have extra expenses that would offset those expenses for operating the other amenities that are closed. Questions about should we postpone collection of assessments during the pandemic? Again, if you postpone collecting, you're running the association at the risk of defaulting on its obligations. You've got vendors that you have to pay. You need to keep current on your insurance, your management contract if you're professionally managed. You can't default on any of those or you're going to be in a world of hurt. So plus there might be statute of limitations that affect the time in which the association can pursue or foreclose your liens. Some of that may be, you know, postponed, like Matt talked about. Some of those time sensitive things, you're getting kind of a bump because of the moratorium. But that doesn't mean that you shouldn't be moving forward. You can still file cases. You can file the case in conciliation court. They're not holding hearings right now, but you can get your claim filed so that it's of record and you've done what you need to do to avoid any statute of limitations claims. Foreclosures are still going forward. There have been a couple counties that have said that they weren't holding sales during the stay-at-home order. To my knowledge, all of the ones that said they weren't doing sales at all have now started doing them again. But there was a period of time where it was county by county as far as who was holding sales and who wasn't. So we did have to, Anoka County was one of those that wasn't doing any sales, so we had to postpone. But they're back up and running again now that the stay-at-home order is not in place. As far as collections, again, not just the statute of limitations, but think about, not every homeowner is financially impacted by this whole pandemic. There are certain businesses that are, booming as a result of the pandemic or, during it. Other people that may be retired or whatever are not affected by layoffs and other things that are happening as a result of the pandemic. So not everybody's affected the same way. Fortunately, Carly, Matt, and I, we're doing all great. People still need homeowners association attorneys. So not everybody's been affected by that. And so to say we're not going to collect assessments just doesn't make sense because it's not affecting everybody in the same manner. A lot of people are being furloughed or laid off. Again, other businesses are doing very well. And even, a lot of people are qualifying for the unemployment plus that extra payment. So some people are actually doing better right now than they were while they were employed. Not a lot of people, but some people would be. Right now, a lot of owners were probably delinquent long before this all happened. And so there's really no justification to say, you owed us $8,000, we started collections and now the pandemic hit and so we should just stop, Or it could be, we have people that their delinquency is because of fines for rule violations or other charges that they could have avoided and they didn't. And so why should they be given a break? So just not collecting your assessments, I think, is also a violation of the board's duties to act in a fiduciary manner to the association. So we do recommend that you still send your delinquency notices, follow your collection policies and timelines, continue to file lien statements to protect your interests. There's been some suggestion that associations voluntarily put their own moratorium on foreclosures. That's up to your association if you want to do that. But I don't think it should be all or nothing. I think it should be on a case-by-case basis. Boards certainly can and should be sympathetic towards members who are in financial hardship because of the pandemic, because they got laid off, lost their job, whatever, and work with them and get them on reasonable payment plans. You can consider waiving interest or late fees if they comply with those payment plans. That sort of thing. But remember that any policies that are tailored for the situation need to apply equally to everybody, all of your owners that are similarly situated who request them. So you can't say, this guy's a jerk, we're not going to give him a payment plan if we would give somebody else a payment plan that's in the same situation. So that's kind of the real quick on collections, assessments, that sort of thing. And then I wanted to talk just briefly about rules, not the rules that you would put in place to deal with the common areas. I think Matt did a good job of talking about what the board's authority is there. But just your general rules that you've always had in place, or maybe not always, but that you had in place before this all happened. Again, there's been questions, should we, kind of hold off on enforcing our rules because of this whole situation? Same kind of thing. No, you should be enforcing your rules. Failure to do so can affect the value of the property. It can affect how people live in the property. Things that are creating nuisances or other issues for other homeowners need to be dealt with. Now, there are some exceptions, or could be some exceptions that would warrant special consideration because of the pandemic. I haven't run into it, but we've heard stories about, in other places where healthcare workers or people that have the virus or have been exposed or in quarantine have requested temporary waiver to park a camper in their driveway so that they can live in the camper and not expose their family to the virus. Something like that, if you get that kind of request, that seems reasonable. It's a temporary thing, and it's specific to the health and safety issue. So that might be something where the board wants to consider the request for a waiver of the rule in that kind of situation. But otherwise, unless what they're requesting or the violation is specifically the result of the pandemic or things that are related to that, I don't recommend that you waiver at all from your normal rule enforcement policies. Now, as Matt mentioned, MHA requires notice and a hearing before you can fine somebody for rule violations. So that can get a little tricky when we're still not meeting in person. Even with the stay-at-home order being lifted, a lot of people still are social distancing, not getting together. You can still hold those hearings remotely if that works, via telephone, via any kind of web platform, etc., where you can communicate with that homeowner and give them that fair opportunity for a hearing. MHA doesn't say anything about how the hearing is supposed to be conducted or anything, just that they have an opportunity for a hearing. So if there's some reason why you couldn't effectively conduct a hearing remotely and don't want to do it in person, then the board can consider either postponing the hearing or just try to work with your homeowner to resolve the issue without having to have the hearing and the fine and that sort of thing. And then finally, I just wanted to briefly touch on, we get a lot of questions about what do we do if somebody in our community does have COVID? Can we force residents to notify the association if they test positive? Probably not. And even if you could, I wouldn't recommend it. You should strongly encourage your residents to voluntarily notify the association if they've tested positive. Especially if you have, shared interior common elements or common amenities, even if your amenities are closed, but you have, mailroom or any other place where that person would be that it could impact other people. The association certainly would want to know. You can't force somebody, but you should strongly encourage them to self-report. Assure them that if they do, that information is going to be held confidential. You're not going to tell other people who has it. But it helps the association to ensure the proper protocols are in place, not only to maintain that confidentiality, but to do what they can in order to protect the other residents. So what should you do if somebody has self-reported? You can confirm with them, first of all, that they have tested positive, and if they have, that they are going to self-quarantine. Hopefully they will do that without you having to do anything about it. You can ask the resident if they wish to self-report to the community that they have contracted it. If they do, provide them with a communication vehicle to do that. If they don't wish to self-report, I think the association should still inform the membership that a case has been confirmed in the building, but not providing any identifying information about who it is, what unit they're in, anything like that. Just the same thing, any of you who have kids in school or daycare, that they do if somebody's got strep or pink eye or any other communicable disease. They post a notice that a case of strep has been confirmed within the school on such and such date, period. So that now the community knows that there has been a case in the community. They can do whatever they feel is necessary to protect themselves, but you're not giving out that personally identifying information. And then finally, just do what you can to assist that member to successfully quarantine. So connect them with resources, including any volunteers in the community that can help them with things such as bringing them groceries, getting their mail or packages, taking care of their animals if they have them, that sort of thing that would help them successfully quarantine and stay inside. The board or management shouldn't really take on these responsibilities that could, expose you to potential liability, But maybe if you have other volunteers in your community that said, you know, if somebody has this, I'm willing to do these things, you can provide a list, you know, connect people with each other. You know, if any of those volunteers get infected, then obviously we want to, you know, follow that process and do the trace and contact the association among once you are confirmed of that, so that you can figure out if you've got a, you know, a panel of volunteers, figure out who else that person has helped and make sure that they are notified to take precautions or to get tested, that sort of thing. And that's sort of all I wanted to touch. I mean, there's a lot of things that you can, you know, talk about in regard to that, but we're already over time. Quickly, because we had a couple questions about this, and Matt touched on the eviction moratorium. You know, mostly that impacts the rental community, but it also affects co-ops, which are CICs. And so those were running into issues because typically, at least when I work with a co-op on a collection matter, the easiest way to proceed through that, rather than trying to foreclose on their share within the community, is just to do the step-by-step process and terminate their membership. If they're not paying, they don't get caught up, get on a payment plan, whatever. And then once the membership is terminated, then you can evict them much more easily than you can for just simple non-payment. Of course, all of those options right now are on hold during the eviction moratorium. And so with the co-ops that I'm working with, I'm just strongly recommending that they do what they can to get these people on a payment plan, you know, and what was considered reasonable before, you know, maybe different than what we think is reasonable now based on the current circumstances. So you kind of have to weigh that out, but get them on a payment plan, do what you can to get them paying something towards that delinquency, in addition to their ongoing assessments or carrying charges or whatever you're calling them in your cooperative. Because we can't evict anybody right now. You can start the process, because even if you're terminating membership, you know, it takes several months to get to the point where the membership is terminated. So we should still start the process as far as sending the notices and all of that sort of thing. But, you know, we're not going to be able to evict until that is finally lifted. And like Carly said, I fully expect that the governor is going to extend the emergency declaration on June 12th. I don't know for how long. I think he's allowed another 30 days unless the legislature vetoes it, which who knows, but I don't think that'll happen. I think it will get extended, and then we'll have to see what kinds of executive orders remain in place or get put in place at that time. But I think this is going to go on longer than just June 12th. I think there was, so we talked about removing members from a cooperative. You're not going to be able to do that until, I mean, you can ask them to leave. It's not necessarily terminating a lease if you've terminated their membership. So I don't think that that moratorium applies to co-ops, but you're still not going to be able to force them out until the moratorium is lifted on that. I think that was about it on that collection stuff. We do have some other questions that came in ahead of time, and then looks like Sandy's posting a couple more. So I'm not sure who wants to take what. Maybe we should all just jump on at this point, and then we can kind of do our panel.
Yeah, if everybody would like to hop back on. I think a lot of the questions that were asked were addressed, so I'm going to kind of work in reverse order with the most recent questions. I know we talked about masks, and somebody is asking with a recommendation, if you're requiring vendors to wear masks on the property, should you therefore require all people, or is it okay to just require vendors?
Oh, I think Matt's muted.
Matt's on mute.
I was trying to say, I
There
think
you
that
go.
would be a poor decision. You know, the mask policy is something that previously was recommended, I think, under the CDC guidelines. If I'm not mistaken, they've now walked that back, or maybe not. I guess I can't keep up with it. But you know, there's no obligation to require masks in public spaces unless you're, I think, in the city of Minneapolis or St. Paul. So the association should have some discretion on what they want to do with that. I think a better policy is one that's applied even-handedly to everybody. And then there's no question about who it's applying to, or no question, is this person a resident? Is this person a vendor? And I think if you're going to require one to wear masks, the best policy is probably to require everyone to wear masks. But I think the board would have some discretion on that if they thought there was a reason why they wanted to have that applied just to vendors and not to residents. I think the better policy would be have it either apply to all or none.
All right, thank you.
I agree.
Yeah,
We have somebody asking if it is okay to send members a late notice during this time.
absolutely. Like I said, there's none of the moratorium. One of the versions of one of the supplements to the CARES Act was seeking to, and they might still come back to this on the federal level, seeking to put a moratorium on all debt collection. I would urge everybody who's in the audience today to contact your your senator, your federal representative, and ask them to vote against that. You know, that really kind of ties the hands of associations, which are, you know, nonprofits, but they're not qualified under any portion of the act currently to receive any federal aid. So your association's not going to get any aid, and if you can't collect assessments from delinquent owners, it's really going to tie your hands. But currently, there's nothing stopping the association, so you should go full force with, you know, being reasonable with people who have been impacted by it, working with them to get them on a payment plan, but don't stop collections. Absolutely send those late notices, file liens, everything that you can, you know, up to and including whatever you think is necessary. Work with your attorney on that on a case-by-case basis, but yeah.
All right, and here is a question I believe would be for Carly. Somebody is wondering if you can say what the specific statute is that addresses doing voting, et cetera, for the board via email.
Yep, the statute about unanimous written consent via email, that's Minnesota statute section 317A dot 231 subdivision 3.
Thank you.
And once you get into that 317A, that's going to be all the rules about board nonprofit corporations, and in that right around that section, it'll have all the other parts that we were talking about as well. I'd be happy to list the other ones too if people wanted to hear them, but that sounds boring.
Right. For properties with federal funding and evictions, if there is one client in the building receiving rental assistance, I'm reading this verbatim, but federally funded, is the entire building considered federally funded or only that unit?
So if I'm understanding the question, there's one tenant who's getting some kind of rental assistance, so that wouldn't apply under the CARES Act. What you want to look at is the manager. You should probably talk to the property owner. The property owner is going to know what type of financing was obtained, if there was federal tax credits, or if it was a federally backed mortgage that was used to purchase or to refinance the property. That's when those restrictions in the CARES Act would apply. So it's not based on tenant receipt of financial assistance. It's based on the property owner using that type of financing for the building.
All right. And again, here's one that I will read verbatim, and I'll let you decipher this. How do all of these things apply to a resident-owned community? They have a board of directors and they would like to be able to apply this. Is there a distinction with a resident-owned community?
They're all resident.
All of what we're talking about is.
That's what I thought. So
I wonder if they mean a co-op.
There is somebody asking for some question, yes, for how all of this applies to co-ops.
Okay.
I don't know if we have time to address that, or if that would be better if the individual would reach out to one of you to have that addressed.
Well, really with co-ops, there's no difference in anything that we're talking about other than, like I said, the eviction moratorium is going to apply to them because they are subject in large part to landlord-tenant law. So they're not going to be able to evict for people being past due or rule violations or anything like that that might be in their governing documents that would allow them to evict. So that's going to be placed on hold. That is unique to co-ops because most other, condos and townhomes don't have the ability to evict owners or members. Other than that, everything we're talking about applies equally to co-ops. Some co-ops are not, just like some townhomes, are not covered under MCIOA. So they may not have the benefit of those provisions of MCIOA. That's not any different because of COVID. That's just how it is. And so they have to look at their governing documents to see what they say.
All right, and there were just a couple more questions that had been asked, but they had been answered. Things about the pools, which were addressed. You talked extensively about that and about whether or not larger groups can gather groups of 10 or more. So I feel that the other questions that were submitted early during the presentation have been addressed. However, I would encourage any attendees who are with us today that if you do feel you have a question that was not addressed or you just didn't get your question submitted, feel free to reach out to any of our 3 panelists today, and I'm sure they would be happy to help you. Or as they said, you can also consult with your own legal counsel. And so with that, unless any of our panelists have anything further they wish to add on.
Stay safe out there, everyone.
Right, take care of your families.
Keep the pool closed is my vote, but.
Say that again?
Keep the pool closed.
Wear a mask. So
it's not worth it.
right, stay safe, everybody.
Okay.